My name is Debbie Hyde. I'm the general manager of KUT, Austin's NPR affiliate, and KUTX, which is the Austin Music Experience, if you'd like a lighter bit of information right now and in these days. I'm so glad we get to kick off this conference with what I think is going to be probably the hottest topic. It's a great way to get started discussing the the First Amendment and freedom of information issues. I will do a quick intro of these folks, but you'll see their full intros in the pamphlet if you don't mind taking a look. But let me start off with Shirley Robinson, who is Executive Director of the Texas Library Association. They have 6,000 members, and they are probably, I would say, 6,000 members under siege right now. There's a lot going on in the world of public libraries. David Dorr, who is the faculty sponsor for New Voices Texas, but is also a member of the faculty teaching journalism over at Aikens High School, where he also is advisor for the student newspaper. And Tom Leatherberry, who is a partner at Vincent and Elkins. He's a director of the SMU Dedman School of Law First Amendment Clinic, stays very active in freedom of information issues, is a former president of this foundation, and is also a recipient of the James Madison Award from the Freedom of Information Foundation of Texas. First Amendment in public schools. Right now, we're looking at, PEN America basically came out with a report recently that said Texas has the most banned books, libraries that are banning books in the country. We have a more than 3 decades old law that was brought about by a case back in 1987, I believe, Hazelwood, that makes it difficult for high school student newspapers to do what they need to do without prior review or prior restraint. And in the state of Texas, the interpretations of the Hazelwood decision from the Supreme Court tend to be very broad, I would say. And then, we also have classroom curriculum that is being debated quite a bit. Teachers that are feeling like they're not able to talk about some of the issues they want to talk about, being accused of, teaching critical race theory and things like that. And so we have, the First Amendment has always been a big issue in public schools, but I think that right now you've got those issues all coming together at once, probably, kind of a peak time for that. Shirley, why don't you kick it off by talking a little bit about what you're seeing in the school libraries right now?
Absolutely. Well, good morning, everyone. It's an honor to be up here with my colleagues. So again, I serve as executive director for the Texas Library Association. We're the largest state library association in the country. Our members are librarians and library supporters from academic, school, and public libraries, as well as special libraries. So about a year ago, we're about to come up on our anniversary of the Krause list being released. We started hearing of incidences across the state and in several primary geographic areas in Texas that's really kind of spread all over the state of books being challenged within our school libraries. And those books related to topics around LGBTQIA issues by authors of color, stories about race, racism, sexuality, etc. Since that time, we have seen demands and requests from our legislators and from the governor to revise existing policies that were already in place that were working perfectly fine, to further restrict access to those topics. Libraries and librarians are professionally educated. Librarians have a master's degree in library science. They teach in schools for at least 2 years and work with professional reviewers to curate collections that serve the diverse needs of their particular community and audiences. So fast forward to where we are now. School came back into session in August. We very quickly launched into a number of policy revisions by school boards. We have groups of angry mobs showing up at school board meetings, really on both sides of the issue. It's created a very divisive culture. And school districts across the state are really grappling with how to resolve this issue without creating policies that are going to really mean that students will not have access to libraries or books. So it's been a hotbed for us. I'm literally taking 2 to 3 calls a week from librarians in distress. Their staff are resigning. They're seeking legal counsel. So it's a really, really challenging time, to put it lightly.
Now, David, in that political climate, you and your colleagues have been dealing with the Hazelwood decision for, since 1988. But in that political climate right now, what are the things that you're seeing, and what are you concerned about with student free press?
We spoke this earlier this week about this briefly, and I I guess wanted to tell you and everyone here that the student free press has been under siege for as long as the Hazelwood decision has existed, and so what you're seeing is basically the dismantling of the high school press for that long a period of time. You would probably be shocked, to see the overall number of actual schools that produce high school newspapers these days. We have, more than 1,000 school districts in the state and many more thousands high schools. You would think that maybe each one of them would have their own high school newspaper, and that is not the case. I often attend journalism conventions where we do see great student journalism being produced in Texas. But it almost seems very capricious about where it happens, because it seems to be it only occurs at schools where the administrators let it occur. And if you happen to be in a different part of the state where an administrator doesn't basically respect and allow that kind of coverage to happen, you don't have a free student press in the high schools. And of course, I'm coming from the newspaper perspective. Most schools will have a yearbook, and they also face their own challenges as well. You've probably seen stories in the news about yearbooks that have had content removed or sections removed because of disagreements over content. And the words from Hazelwood that are so dangerous and have harmed us so much are the administrator has the ability to exercise what's called prior review if they have a legitimate pedagogical concern. And you can imagine that could be almost anything. The vagueness of those words has done serious harm. And so the New Voices organization that students have sprung up to spearhead after other states have passed state laws that aim to clarify the publication process. And the problem with the vagueness of those words, legitimate pedagogical concern, is that it puts too much power in the hands of somebody that really doesn't probably want to be involved in the student press. They have enough responsibilities that is running their schools, and they would hopefully be able to trust their advisors that they hire and the students that have been trained to act responsibly in their publications. And so New Voices Texas is aiming to pass a state law that will protect student journalists, but also just clarify this process. We can eliminate so many of these conflicts if there's more of a clear rules of the road for the administrators, for the advisors, and the students. And we've seen advisors lose their jobs over this. We've seen student publications being censored, and in some cases either shut down. I think what the saddest thing is too is that over decades we have basically trained students that it is okay to accept prior review and censorship for decades, that we have just allowed this to happen. And it happens quietly and under the radar sometimes. And so, unfortunately, that's why we don't always hear about this on a more common basis.
So Tom, you've been at this for a while, fighting this battle, and I'm curious to hear your thoughts on where we are at this particular moment in time when it comes to the First Amendment and public schools, and how that compares to other things you've seen in the past.
Yeah, thanks, and good morning, everybody. I think it's easy to describe what's going on right now as the weaponization of the First Amendment and the weaponization of parental rights. And I think Texas and Florida are really ground zero for a lot of this. What the Florida legislature does and what their governor signs, the Texas legislature wants to do, and our governor wants to sign. And so I think it's a really dangerous place. I was thinking this morning, getting ready for the panel, I need to really just pick another amendment to defend because there's just too much going on. But yeah, I mean, you've got many interested parties in these discussions. You've got parents, you've got teachers, you've got staff, you've got students, you've got publishers, you've got authors. And at the clinic, we've had calls from every, a member of every one of those groups. But the book banning is a little bit like whack-a-mole because there are these new TEA standards that Shirley referred to, but each district doesn't have, they're not mandatory, and each district can adopt its own. And you've also seen really interesting Open Meetings Act problems with the book banning and how that some districts have gone about it. In Keller, according to news reports, the administration delegated the book review function to committees of citizens, and then they wouldn't release the names of the citizens on those committees. And the Open Meetings Act carries criminal penalties with it if you intentionally violate it. And I think the other open meetings implication relates to what Shirley said about the polarized climate, because you've seen school districts clamp down on public comment at these meetings, limiting time, limiting number of speakers, requiring advanced sign up more than usual. And maybe for the purpose of screening who's speaking and knowing what they're going to say. And so I think book banning and student journalism and the critical race theory and the Don't Say Gay law in Florida that I'm sure we'll see in Texas come the legislative session. All of these are being challenged, and just as a teaser, I'll say the other thing that affects public schools, mostly contractors and employees of public schools, is all of the anti-boycott legislation that the Texas legislature passed last session. Well, starting back in 2015 with the anti-boycott divestiture sanctions movement, which was painted as pro-Israel, and continued in the last legislative session with you can't boycott in a very vaguely defined, overbroad, unconstitutional way fossil fuel companies. And you can't discriminate against firearms companies. And you're seeing governments, including school districts and cities, making decisions about who their contractors will be and who their employees will be based on these anti-boycott laws that are really pernicious. And, we may get an answer from the Fifth Circuit on some of these issues soon, because there's an anti-boycott challenge that's going to be argued later this year. But it's a bad time. But you have to find your joy somewhere, and so you celebrate what victories you can and what little worm's eye progress you're able to make in this little corner.
Well, and that's part of the point of these gatherings, is so we can figure out how to find a few more of those victories and keep inching forward. I do want to get back to the anti-boycott legislation because that fascinates me as a First Amendment issue. But when it relates to what's going on in public schools right now, the libraries and student newspapers and the classrooms, it feels like there's a lot of fear that is being developed, and that's going to lead to some, self-regulating behaviors. You touched on this a little bit, David, about the student newspapers that tend to really go after it versus the ones that are playing it safe. Tell me a little bit about that climate and what it means, what it is leading to, even in places where there aren't direct challenges. Both you and Shirley, I'd love to hear that.
Yeah. Yes, self-censorship essentially, yeah, is something that they train themselves to do because they have heard stories about their principals, or they know, of maybe previous things that have happened, and they, choose that this is not something that we can cover because, our advisor could lose their job, that kind of thing. And so fear, yeah, is a big problem right now in the student press. And it's I mean, it's pretty obvious. I mean, like if there's a paper that's like printing and they're winning awards, especially at the national level, then that campus is probably a campus where the the students and the advisors feel more free to do coverage, right? And in places where you don't hear about that student newspaper winning awards and publishing, then there's a good chance that there's something else going on there, and we should look into that.
Well, in the Prosper case that you brought up when we discussed this earlier, sort of shows how quickly that can turn on a dime too. Why don't you talk a little bit about that case? It was back in 2018, I think.
Yes, yeah. So, yeah, in 2018, advisors across the state started hearing about what was happening to one of our very beloved colleagues, who had been an advisor in the North Texas area and had recently taken a job in Prosper. And it's hard to say all the ins and outs of that particular case, but I do know that there were acts that happened that students considered to be censorship and prior review, and they went to the Student Press Law Center, and they got a lot of good help from them. Their various press agencies got involved and supporting the students there, and I guess what I think it shocked a lot of us advisors into action, and also just awareness, because it was one of our own, and if this advisor, who had been celebrated as one of the finest in Texas, could be punished, and that teacher did leave their job at the end of that school year under duress. They, were an example that we can't allow this to keep happening anymore, because, if it could happen there, it could happen anywhere into any of our programs. And anytime we get a new principal, we are very worried what is going to happen, because apparently at this point, it's up to that new principal and how they see the press, and how that they're going to behave and treat the student journalists.
Shirley, what about fear in the libraries?
Oh my goodness gracious. I mean, and we're seeing exactly the same thing. And it's really just amazing to be on this panel and hear some of the other things that are happening within other educator circles. But I mean, but you all know this, there are policy guidelines that help librarians to select materials for their collections, and there are reconsideration processes and policies in place that are approved by the school board. But what we've seen over the last year is just a complete violation of those policies. I mean, we've all saw the story in Granbury where someone, could have been the superintendent, went in and just wheeled out carts and carts of books. So now, of course, we're seeing librarians take that Krause list and go through it and find those materials that are on their shelves and just pull them voluntarily because they are afraid for their jobs. I was talking with a librarian in the Panhandle 2 days ago who is just a wonderful librarian for her school. Some of these groups have targeted her. They took her photo off of the school district website. They're using it as propaganda in their groups on social media. She doesn't have a social media presence at all. She doesn't post anything about library materials, but it's terrifying for them. And we have a professional liability product that we offer, and we have so many librarians taking advantage of that because they're seeing their colleagues lose their jobs either under duress or voluntarily retiring if they're close enough just to get out of the climate. And the risk, of course, with that is that as soon as that librarian leaves, they're going to be replaced by someone who is going to just follow along to get along.
One aspect of Granbury that was very interesting to me as a lawyer was there was a meeting of some school employees, librarians and others, and one of the participants in that meeting surreptitiously tape recorded the meeting for self-protection out of the fear that we've heard, and you've heard more so than I have. And after a lot of back and forth, I think the person who had the tape decided to release it and make it public, and the Texas Tribune and NBC5, I think, were the ones who played portions of that tape, which, pick any authoritarian regime, and that tape could have come directly from that authoritarian regime. It was an administrator telling this group of school employees, reading them the Riot Act about how they were going to cart off these carts of books and that sort of thing. So I'm going to make a banner for our clinic that says, Texas, so many First Amendment violations, so little time. Because that's how I feel 24/7, and I know y'all are on the front lines more than I am.
Well, with that in mind, what are the cases you're watching right now, Tom, that might change things?
Sure. So there's only been one case filed in Texas that I'm aware of about library policies, and that's the Llano County case, which was filed last year and has been transferred to the federal court in Austin. In looking to see what had happened in the case recently, including the transfer from San Antonio to Austin, it was interesting to me that Llano County is being defended by Jonathan Mitchell, the architect of Senate Bill 8, the anti-abortion bill. And he is parachuting into some of these other cases around the country. So we don't have a lot of guidance in Texas, but there are a couple of cases in Oklahoma and Florida. The Oklahoma case concerns Oklahoma's anti-critical race theory law, and it was brought by the ACLU and the Lawyers Committee for Civil Rights Under Law, with a very diverse group of plaintiffs. They have organizations, they have teachers, they have parents, they have students, they have publishers. That case, there's not been any decision on it yet. They argued a preliminary injunction motion seeking to stop the enforcement of the law months ago, and the judge still hasn't decided. I mean, if you look at the claims in the case, it's like a First Amendment exam, right? It's violation of free speech. There's an equal protection claim. There's a due process claim. There's a claim about the right to receive information, which goes back to some of the school employee cases. And it's a very interesting claim. And then there's viewpoint discrimination, since so many of in the critical race theory situation and in the Don't Say Gay law and in the book banning, you see a lot of viewpoint discrimination and elimination of whole tranches of books dealing with certain subjects. There's also a vagueness challenge, because all these laws are really poorly written, and the definitions in them, some terms aren't defined, some are defined so broadly you could drive a truck through them. And really, it's the same situation with the Don't Say Gay law in Florida, which has been challenged by a diverse group of plaintiffs as well. Equality Florida is the lead plaintiff, and there are parents and students and teachers and counselors, and because it's not just the librarians and the teachers, it's the social workers who work in schools that are petrified about what some of them call the criminalization of social work, because their ethical obligations require them to talk about issues that students bring to them, and they may be about gender identity, and they may be about racial slights or perceived racial inequities in the schools. And what can they say? And consistent with their obligations, their professional obligations, and the tension between those obligations and the laws that have been passed by the legislature. So in the Don't Say Gay law case in Florida, many of the same claims: free speech, right to receive information, due process, vague definitions in statutes, vague statutes, overbroad statutes, equal protection, viewpoint discrimination, Title IX for sex discrimination in publicly funded institutions. Also, no decision in that case yet. They decided not to try for a preliminary injunction because initially the court had said they would get a very quick trial. That hasn't happened. And the defendants, the Florida officials defending the law, have filed a motion to dismiss, and that is pending. And the plaintiffs are trying to get discovery, which a lot of times you can't get when there's a motion to dismiss pending. So still to come on that. There's also a challenge in Florida to the Stop Woke Act, which is very similar to a lot of the other critical race theory laws, and has serious repercussions for any public employee, especially teachers and other people who work in schools.
And you think you suspect this legislation will show up here in Texas?
Oh, yeah.
In the next session?
Absolutely. Yeah. I mean, we already have the anti-critical race theory
Right.
legislation, and to my knowledge, nobody has challenged that yet, because I think some of the guidance under that law is still being worked out and developed by TEA or by whoever is developing it. We also have the 1836 project, which fits into my view that you have a lot of there's a lot more prescribed speech, and there's a lot more proscribed speech. So I must compel you to say, you are compelled to teach history the way we want you to teach history, and at the same time you can't mention these other subjects that would round out your teaching of that history. So I think we'll see. Who knows? I'm not a legislature watcher, but I think we'll definitely see the Don't Say Gay law here. And I think that the red meat aspect of that, with an upcoming, presidential election in 2024 that many people are interested in, is sort of irresistible for the majority of our legislature.
Can I just add one quick thing
Sure.
about another piece of legislation that's probably going to be coming forward, and that's related to the Texas Penal Code and the obscenity exemption law. And that is incredibly vague, and it's incredibly dangerous, because one of the tactics that these groups are employing is to go after that obscenity exemption, which is what protects our educators from criminal prosecution for having medical texts and books about puberty and LGBTQ subjects. So that's one item that we know that they're going after, and they're going after it in advance of the legislative session. They're attempting to put into place municipal ordinances in public libraries and schools as well. So that's one to watch.
So you mentioned, Tom, how vague a lot of these laws are, and David, you mentioned that the fact that Hazelwood is written the way that it is, it allows a lot of variety of interpretation. So how important is clarifying legislation, and is that the best that we can hope for in the current political climate? Something that says, okay, there may be guidelines, but let's try to make them uniform in some way.
I mean, David, you should talk about new voices because that's
Yeah.
exactly what that's trying to do.
Yeah,
You may be more hopeful than I am about clarifying legislation.
yeah. I mean, I think we do see it as our best hope. There are 16 other states that have passed these new voices laws. You'll see like pretty clear evidence in states where they have these laws that they're able to report more freely and more doing more real accountability journalism, like talking about controversies on their campuses. But specifically, what the new voices law is, and it's based on model language from the Student Press Law Center. And we consult with them, and we've had some success, I will say, in the I guess it was 2019 session. We had our new voices bill passed unanimously out of the Public Education Committee. Mary Gonzalez was our bill sponsor. We're looking for a Senate sponsor, so if you know anyone, let me know. But
Senator Johnson will be here soon.
I know I'm gonna look for him. But it passed unanimously out of the Public Education Committee, and it died in calendars. But essentially, the bill is clarifying language that really spells out, and it doesn't allow laissez-faire, anything goes, journalism. I mean, it still is following regulations. We're not talking about publishing obscenity and other ethical, violations. So there could still be prior review under a new voices law in Texas, but it's much more limited. And the ball has been moved. The responsibility of the paper has definitely been put more on the students than with the administrators. And that's one thing that I'm always perplexed by is why are administrators okay with accepting the liability of what their students are we're trying to report on? Like, let's make sure the students are responsible for what they're doing in their student publication, allegedly, right? So yeah, the idea is let's make sure that the advisor knows what their job is, what the administrator should and shouldn't do, and what the students are responsible for. So clarification is a key.
And Shirley, for the school libraries, would it help to have something that was statewide TEA guidelines, or is that a whole other ball of worms?
I'm so wary of that. I really am. I mean, as a state, we're structured in a way that we're incredibly focused on local control, and I don't know that we're ever going to get away from that. So I think our best hope really is in respecting the professionalism of our educators and our librarians to follow those policies. I mean, the policy that was in place for many school districts that is dictated by or offered by TASB. TEA does not write policy. TASB writes policy, and then that can be amended or adopted by the school boards themselves to make sure that that fits the needs of their community. But I mean, really, it goes back to grassroots advocacy and making sure that we have fair and balanced representation on our school boards and in our city elected leadership to make sure that the full needs of the community are represented. And what is going to work in Austin is not going to work in Borger, Texas. It's not going to work in Tyler. It's not going to work in San Antonio. So what do you think, Tom?
Well, I think your comment about one size doesn't fit all in Texas is really interesting because increasingly that's what the legislature and the governor have been trying to do, is to make one size fit all. It's what Dean Heather Gerken at Yale Law School calls the new federalism, where there's no flow down to the municipalities, there's no flow down to the local officials. It all stops at the state. And you can see that in things like can a municipality adopt an ordinance prohibiting the use of one-use plastic bags? Well, the legislature didn't like the fact that one of the cities in the valley had done that, and so they passed a state law and preempted all municipal ordinances to the contrary about use of plastic bags at grocery stores and so forth. And there are a number of other examples where you can see the state stepping in to areas that traditionally have been areas of local control, in part for the raw political reasons that the larger cities are blue and the legislature is red, and the legislature is dominated by rural interests more than it should be, and then you have gerrymandering on top of that. So I hope you're right that we like local control, although that leads back to the whack-a-mole problem and the call from Borger that's different from the call in Plainview, from different call from Amarillo. But I see more and more state exercise of control in traditionally local areas of regulation to dictate the policies for the larger urban areas. So that's my take.
One of the things that has always been important about the Freedom of Information Foundation and the First Amendment work here in Texas is that it is very nonpartisan, and especially in things like contract law and open government. We've found partnerships from the ACLU to the Texas Public Policy Foundation. Is this issue any different? First Amendment in public schools, is it partisan, or are you seeing some nonpartisan? Are you seeing some concern from all sides?
I have one bright spot story from this last week. Last week was Banned Books Week,
right,
across the country. And by and large, for the most part, it's completely partisan. And, you're just seeing this play out in local scenarios. But we received an email of an individual who was involved with one of these groups, and these are all very organized groups. This individual has become aware over the last couple of months that what is happening is not about books, as we all know. It's about political control and gaining votes. And this individual came forward and said, "This is not right. I don't want to be a part of this, but I don't know what to do." So we're trying to work with this individual because we know that there are other people out there that feel that way and are starting to understand what the underlying agenda really is.
There seems like to be so much potential for a win-win-win kind of situation for a new voices legislation. That's how I see it. I can see so much convergence why this should be a bipartisan issue and it should not be partisan. I can see, in some communities where there maybe is a perception that an administrator should wield a strong hand and kind of have a lot of control over their school environment. But, I feel like there's various ways to look at it from different, political philosophies that would not be okay with that. So I just think that there's just so much potential for this to be a something that a lawmaker could come back to their community and say, "I did this for your students. I did this for our community so that we can make sure that we have responsible coverage and publishing and journalism experiences." I know one of my biggest regrets, I guess, is how much we've lost in terms of our using our schools as a laboratory to practice democracy through our publications. And when you don't have a functioning press, in your high school, how do you even practice, debates, and coverage? Right. I mean, and so it seems like such a safe place to have these conversations, or it should be anyway. And unfortunately, we're seeing that's not happening.
Yeah, I mean, plus, how do you do that with civility?
Yeah. Yes.
Because the role models that our students and are getting are just horrible in terms of willingness to listen to other viewpoints and that sort of thing. I mean, I think that's the beauty of the First Amendment. It really should be nonpartisan. The funder of our clinic asks us every year when we fill out a report about what we've done and what the students have done, give me some examples of times when you defended speech you hated, because that's what true advocates of the First Amendment will do. I mean, think of the ACLU and the Nazis in Skokie, to go back to the 70s. And think about some of the controversies on college campuses now about whether or not there's academic freedom, and whether or not there are retaliation against more conservative students or more conservative professors. And it really should be nonpartisan, but it's not, because if you look at the legislative debates around the laws we've been talking about, if you look at the legislative debates around the Texas unconstitutional social media law, except in the Fifth Circuit's eye, then they're completely partisan, and it's completely red meat, and we're doing this for the base. And that law was passed because there was a perception that big platforms were censoring conservative viewpoints. And this is the solution that's going to lead to a Twitter feed that you don't want to read, because there can be no moderation of content. So I think unfortunately, I wish I could say I think we've hit bottom, but since the legislature comes back into session in January, I don't think we have yet.
Yeah. Well, I want to open it up to questions from the audience, but I have one big question for you all first, and that is, given the folks in this room, media, public officials, government agencies, law, everyone that's in the room, what can we do to help to help out the First Amendment in public schools?
I mean, I think so. I'll say for our organization and those who have been fighting in defense of it, the support of the media has been incredible. National media, local media, small town newspapers, all the way up to all of the major media markets. So I just want to say a huge thank you to you all for covering the story, for really digging in there and taking all the different viewpoints, and just continue to help us do that, please.
I want to say that we've had some really good supporters from the media and others that are, I guess what I'm going to say is supportive of the student press. And I think that's what I want to say is, like, don't forget about us. I think sometimes the student press, especially high school press, is not taken seriously. And, that's our future, right? Like, to train these folks to be responsible, ethical, accurate journalists. And this is their, training grounds for the future. And so anything you guys can do in terms of like bringing light to this issue would be very helpful, because it starts here. It starts at the high school level, or even in middle school. And so let's make sure that we're not forgetting about it, and ask questions about what is going on at my local school publications to find out, how do things operate? Do they have a paper? Is it online? Is it printed? Just start asking more questions about that. That would be helpful.
Yeah, I don't have that much to add, but from a lawyer's perspective, we try to see patterns in litigation, or patterns in problems that, it's always good to solve one person's problem and get them the documents they want from that particular agency or that particular city or what have you. But if you can spot patterns and you can bring a lawsuit that has greater impact than just one person and one situation, then that's a win. So our clinic is there. We do a lot of Public Information Act work. We do a lot of counseling. UT has a First Amendment Center at its law school. There are other resources out there. The FOI hotline is probably still working, although I aged out a long time ago. But be aware of the resources that are offered. The Student Press Law Center is a fabulous organization. The Reporters Committee for Freedom of the Press is a fabulous organization, and there are some resources out there. So let us hear from you, and we don't have the resources, all the resources in the world, but we know a lot of people and can maybe point you in the right direction and maybe give you some assistance.
So would love to hear your questions. We don't have a mic back there, but so be sure to project and I will repeat the questions for the panel before we go. Wanted to explain the obscenity exemption.
Yes. So in the Texas Penal Code, it's 43.26, I believe. There is a clause that defines the obscenity exemption, and Tom might be able to better speak to this than I, but it's a very broad definition that allows educators to distribute materials, medical, health, etc., and protects them from prosecution. And so these groups are looking to repeal that obscenity exemption so that they can go in and criminally prosecute librarians and educators for having materials on the shelves that have already been placed there according to approved selection guidelines.
Yeah, I think that's exactly right, Shirley. And, this doesn't have to do with the educator's exemption to the obscenity law, but obscenity has also been made into a partisan football by at least one DA over in East Texas who's tried to prosecute Netflix for the distribution of the film Cuties under the commercial obscenity statute. And there's Netflix filed a federal lawsuit and has filed a motion for preliminary injunction to enjoin the prosecution of them for the distribution of that film. Again, Jonathan Mitchell has parachuted into that case on the side of the DA and at the preliminary injunction hearing. And it's an area that I think that's probably not the only legislative change that the legislature will be looking at this coming session. And there could be great repercussions for the First Amendment and non-obscene speech, controversial speech, but non-obscene speech, in addition to whatever is defined as obscene.
Shirley, I know the Georgia law is pretty recent. Have there been prosecutions already under that?
Not that I've heard of. We're meeting soon with the ACLU, though, to start digging into the issue because we know that a number of states have attempted this and Georgia was successful.
So that's a great question. How are we seeing censorship when it comes to the digital side of the student media?
Yeah, I think that might even be more common these days because there are fewer print editions, but obviously print edition has a little more limited reach. And so it's much more likely that somebody could come across an article on an online high school newspaper website and it's maybe easier for an administrator to make that article disappear, like if they don't like it, if it generated too much controversy in their community. And then it really is gone because it's not printed anywhere, right? And so, it's definitely happening on a regular basis. And again, we don't always hear about it because there's just so much fear about, am I going to lose my job if I'm the administrator and I don't comply with the order? I think I remember there was a case in East Texas this last spring, and again, like sometimes like the details are nebulous because I'm not there. I don't know that community. I don't know exactly all the ins and outs of it. So I'm nervous to speak, in specifics about it, but it does happen. And with digital, it's even easier for it to happen, I think, because honestly, like it may be set up that the administrator has the login to that website. I don't know, every school, but imagine that they do and how easy it would be to hit delete. So.
Tom, when it comes to digital media, in particular social media, among students in schools, I assume we see a lot of activity around that. Students being told what they can and can't say about the school on social media.
Yeah, I mean, one of my favorite fact patterns of the last U.S. Supreme Court term is the cursing, Snapchatting cheerleader. And You know, that case, the cheerleader won because it was sufficiently off campus and didn't cause a kerfuffle on campus that the administrators thought it was going to cause when she was upset by not making the varsity cheerleading team and posted the F word and some other choice words on Snapchat to some of her friends, which, you know, deleted, but of course somebody saved a screenshot of it somewhere and told the administrators. So I think the relationship between and the school district in that was called Mahanoy, so that's what I know to call it. But the relationship between that case and Hazelwood are really interesting because they both purport to turn on whether or not the administrators in making the disciplinary decision or the censorship decision had legitimate pedagogical purposes. And, you know, I think the discretion that gives school administrators, particularly in the digital space, is very dangerous because it's, you know, I think probably even post hoc rationalizations for legitimate pedagogical purposes or post hoc rationalizations based on that article caused some upset on campus, or, you know, students wouldn't eat the food because the article was about how terrible the cafeteria was. Then I think legitimate pedagogical purposes is a pretty expansive term, even though it should be limited to only on-campus stuff and school-sponsored stuff like a digital publication.
Yes.
My name is Jeff Morgan. Thank you for this discussion. It's very fascinating. My question is this. I think that this whole argument is being perhaps incorrectly framed. It's more like First Amendment versus political ideology. I think it should be looked at more First Amendment versus parental rights issue. Because what I've seen as I've watched this is the parents that are rising up against this. When I was going up to school many, many years ago, we did not have access to the internet, Playboy, Penthouse, Hustler, whatever it may be. We did not have that. And yet when parents go in front of the school boards and they start to read excerpts from books that are in their magazines, they are equally, if not more, pornographic than what those visual representations would have been. So I'd like to see if you could address this from that issue, how we can solve this from a parental rights versus First Amendment issue, because what I hear you saying, and maybe I'm incorrectly hearing you, parental rights be damned in a sense. And I don't think that that's a good way to look at this. Parents should be able to enforce some standards for their children. That's my perspective, but I'd love to hear your comments. Thank you.
Shirley, you want to take that one?
Sure, absolutely. So thank you, Jeff, for that question. That's a great one and a really important one to focus on. And I want to emphasize the fact that in the state of Texas, parents have greater and stronger rights than in any other state in the country. So librarians and educators are there to work with parents, and there are incredible protections in place and abilities for parents to make a decision about what their child will or can or cannot read in the school library, in the classroom. We know that language arts teachers will send out forms at the beginning of the year and say, this is our reading list for the year. You can choose what your child does and does not read. Parents have the ability to see what content is available in their school libraries online, and also define what books they may not want their child to read. But parents do not have the right to make that decision for other families' children. So that's the really important piece to understand here. And those parents have the ability to challenge a book if they don't like and understand why it's there. But I think the point that has been misunderstood about this whole conversation from a school library perspective is that librarians are placing these materials in specific age relevancy groups and collections within the library. And so it's not like the book Genderqueer is available in an elementary school library. That's in a high school library if the librarian has chosen to bring that book in, or it's come in through their selection guidelines.
Good. I think one other area that I would bring up is there's been some really good media coverage in the state that has pointed out that some of these, particularly library campaigns, are a little more astroturfing than grassroots. They're not necessarily coming from the parents in that community. They're coming from outside of the community into the community as a, as Tom pointed out, it's a political issue that a lot of folks have made.
Yeah, I mean, I completely agree with Shirley, and nobody's saying that parents don't have control over what their children have access to and bring home. It's the blunderbuss effect. It's like nobody can read that. That's not helpful to anybody. Nobody needs that book. Nobody needs that information that is so pernicious. I mean, I wrote an op-ed about book banning, and it's a funny story, and it's kind of falls in the nature of just spell my name right. I was defending a libel case that was brought by a new website called Dallas Express, and they decided to write 4 really derogatory articles about the clinic, and I was called pro pornography, and I was called pro this and pro that, all based on anonymous sources and another plaintiff that I had defended a lawsuit against. So I think the combination of outside impetus, parents haven't read these books, right? They haven't read the books. They just get the list, right? These are the books that you don't want your children to read. And then the blunderbuss effect of trying to take them off the shelves for everybody, regardless of what their family situation and what their needs are educationally and pedagogically, is what's dangerous.
It has been interesting to see in the cases where it has gone that far, where the parental committee has, the books have been pulled, and the parental committee has gotten together to review those books. The Houston Chronicle did a great analysis that showed, how once the parents actually reviewed the books, most of them made it back on the shelves, and it was very well done because it talked about where all the districts were in the process, and how ultimately, when content was put in context, the parents were saying, okay, we can do this. Mm-hmm. Yeah, sure. Mm-hmm. Sure, and there is for books too. I have a freshman at high school here in Austin, and since fourth grade, I've been getting the list that comes that says these are the books that we're going to read, and gives information about them, and it gives you plenty of time to review them yourself, and then you can say whether or not you want your child to read those books, and I believe that's standard practice. I don't think it's just my district.
It does vary by school district.
Oh,
I mean,
okay.
there's one, we're really concerned about the opt-in option, because what that means is that if the parent misses that form coming home from school, or they forgot to check that box, that student will not be able to go to the library at all. And the library is an incredible and very important resource for students for a number of reasons.
Debbie, can I just add one other thing
Sure.
that's sort of related to this, and why I use the word weaponization of parental rights, and not to the exclusion of parental rights at all, in the ways that we've been talking about. But one aspect that I didn't mention about the Don't Say Gay law in Florida is it copies the abortion bill in Texas, SB 8, in that it creates a private enforcement mechanism and allows any parent with a concern about the subjects discussed in a particular classroom or particular lecture to file a lawsuit against the school district. They have to give them 30 days notice, but they can get costs and attorney's fees. And it's probably like SB 8 in that it's not reciprocal, that if the school district wins, it probably can't recover attorney's fees from the parent who made the complaint. And that's just, I mean, what kind of atmosphere does that create for the librarians, for the student newspaper advisors, for the social workers, for the teacher, just everybody? I mean, that's just toxic. And why you would want to create that type of environment by incentivizing bounty hunters in the educational space, I'm at a loss for.
It's a good question. How do you describe the difference between the moderation of content and the censorship of content? Where is that line?
I would answer that by saying that moderation of content can include censorship of content. I mean, that's just an extreme form of moderation. And that's why you had the social media law passed in Texas and in Florida to prohibit the ability to moderate content based on viewpoint and based on location of the poster. I think one way you moderate content is you have these policies and guidelines and procedures and appeal rights and hearing rights and that sort of thing. Whether the moderation involves placing a particular book in the high school section rather than in the junior high section, or whether it involves not offering the book to anybody in the district. In the social media space, I'm sure school districts have adopted social media policies, and they may or may not be constitutional, but what you have is private actors, which unless you're in the Fifth Circuit, you have these large platforms that have the ability as private actors, non-governmental officials, to adopt their own terms of service. And those terms of service include guidelines for content moderation. And do they follow them accurately all the time? Probably not. But consider the volume of material that they're dealing with. It's not a library collection. It's everybody who's tweeted about this program, and it's everybody who's tweeted about anything today. And so I think from the government space, what you need to do is to adopt policies that don't discriminate against viewpoints, that give all the parties interested in the process, parents, publishers, teachers, librarians, staff, the ability to challenge either the decision to make something available or not make something available. And you provide the process that, ultimately, if somebody's not happy with that, they might end up filing a lawsuit under civil rights statute. But it's probably not a very good answer to your question. It's a little wandery, but that's what I see.
Yeah, and Tom, I would say a key there is transparency about the process.
Yeah.
I do think
Right.
there's a lot of misunderstanding about, what schools are already doing to, moderate content, to make sure that it's age appropriate and to make sure that it is, that it's not just one person making these decisions about, what's taught or what's in the library or, anything else. That there are typically processes in place, and I think that is one of the proactive things that can be done is explaining what goes into making those decisions, so that the folks who might have the initial knee-jerk reaction to a social media post that says, my kid brought home this book and it had this horrible thing in it, has some understanding of, oh, this didn't just show up on a shelf. It, went through a process.
Debbie, that's why I think the Texas Public Information Act and the Texas Open Meetings Act are so important in this space, because, and I would encourage everybody in the media here to watch, who reports on school districts, to watch the postings and to ask for the policies, particularly when they've been changed. And you're entitled to that information, and you're also entitled to have them have certain discussions that don't involve attorney-client matters in public, and you're entitled to a vote in public. And I think a lot of these school districts were trying to react so quickly that I don't think they observe the niceties of the laws that we already have in place to ensure more transparency.
His point, if you didn't catch it, was that that there isn't really enough media coverage of what's going on at these school boards and in the local school districts, schools overall, and that that would be a benefit in particular to have more of that coverage, because as we all know, that's where it all starts. I mean, it is, and it's interesting to see that politically that those school boards have started to attract attention from a national level down. That's something different from what I've seen through my career as a reporter.
I'd like to respond to that, because I often tell my students when we're discussing story ideas and developing our coverage, like some of the paid reporters in town would kill to have the access that you do. Like, you guys are right there in the middle of it. The conversations you're having at lunch are all story ideas, guys. You just have to think about it that way, So, and in some ways, it could be, something that's just happening at that local campus, but then it could be something that's bigger, that might be more kind of a parent concern, that they want to know what's happening in their schools. And the only place that's, has reporters in place that can cover it are the student journalists that are there on those campuses. So I think there is a role to play. We, have a tradition at our campus that we actually mail home our newspaper twice a year. So our parents are seeing it as well. So, I would love to see that happening all over the area. Yeah.
Yeah, and that is, that's another way to engage parents in the whole process before, before they're getting excited about something they've seen on social media. So, last question. Well, I think one of the ways you can contribute is exactly the way you're doing now, getting here to get informed about the issues so that you can look out for them within your communities. The other ways are actually becoming a part of the Freedom of Information Foundation, helping out with various government, open government causes. The fact that so many university campuses do have a First Amendment center of some sort is something that you might want to look into on your local college campus as well.
At SMU, there's a free speech study group that is campus wide. So it's not just the law school; it's undergrad professors and undergraduate students and graduate students and law students and law professors. And that seems to be a valuable way to get together and kind of exchange ideas, although sometimes it gets a little wonky and theoretical for my taste. But you could start something like that too.
I have two suggestions. One is SPJ would get involved with your chapter of Society of Professional Journalists, and oftentimes they have mentorship programs with student journalists at high schools. That would be wonderful, because sometimes they listen to you, but more than the teachers sometimes. And then, oh my goodness, I had another really killer idea, and I just, oh, look at that. I have to take attendance, guys, so I'm supposed to be a class right now. Okay. Also, when you graduate from your high school newspaper, don't forget about them. That's a refrain I've been saying today a lot, but I think you forget, like, when you go to your college paper, you have so much more freedom. You forget how restrictive it was when you were in high school. And so think about things like New Voices and how you can, fight for your younger colleagues.
And I'll just add one little plug for TLA. We launched a grassroots coalition called Texans for the Right to Read. in March, and it is specifically for non-librarians, folks in the community, media, legislators, business and community leaders to help support the efforts. And we have about 3,500 members so far. So Texans for the Right to Read. And if you know a librarian who is in distress, send them to TLA. We have a helpline. We have lots of wonderful resources for them.
Great. Well, I want to thank you all for kicking off the conference for us in a really great fashion. Appreciate it very much.